the bench of Justice N.V. Ramana, Subhash Reddy and B.R. Gavai, they have not struck down or dealt with any of the actual orders themselves and whether those were illegal. But what they've said is that here is the law for how you assess certain things, and then on the basis of that you can now go and challenge a lot of these orders, and to facilitate that they've given certain instructions. So let's see what they've done. They first said that, look, when it comes, and this is a huge development, they've said, look, when it comes to the right to freedom of expression, usage of the internet for this is part of your fundamental right to freedom of expression under Article 19(1) of the Constitution. And that means that any restrictions on your right to freedom of expression using the internet have to be assessed and have to satisfy the same test as any other reasonable restrictions which would otherwise be imposed.
It's the first Supreme Court judgment which spells it out in unequivocal terms. That is, the internet is part of fundamental right in India. Especially, there are various aspects of the internet. There is commercial aspect where people used to carry out business, for health. So the Supreme Court emphasized that internet today is really a part of life.
Now they've also, in addition to this aspect of the internet shutdown rules, they've also said, look, here's the look at the internet shutdown rules. It says that these are for temporary reasons. They cannot be an indefinite internet shutdown.
The orders must have material facts. They must say why you are restricting and what are the parameters on which the state may restrict. Only if it meets the doctrine of proportionality, which means you cannot have an excessive or unnecessary or disproportionate response. You cannot ban all internet because you apprehend have some vague apprehension.
The next thing which the judgment says, it says that all the orders, whether it's the Section 144 orders or the internet shutdown orders which were passed, all of these have to now be published and made publicly available so that they can be challenged using the law.
The orders of the review committee, which has to complete its task within 7 days, will have to be placed out in the public domain, and that can be challenged either before the High Court or before the Supreme Court.
The court has also said that any order on internet restrictions will come under judicial scrutiny. This is most important. So the government of India should not think that they can get away with anything and nobody is going to ask them. So by saying this by the Supreme Court that any order with regard to internet, it will come under the judicial scrutiny, I would congratulate on the Supreme Court for this.
The Supreme Court has delivered the first big jolt of the year 2020 to the autocratic and the fascist regime of Modi-Shah duo. Supreme Court has held that the internet freedom is part of freedom of speech and expression. That is, it's a fundamental right. More importantly, Supreme Court has held that Section 144 of CRPC on peaceful assembly cannot be used to curb dissent. All over the country, Modi government has used Section 144 to curb the voice of the youth and the students. I think this judgment is a slap on the face of that fascist regime.
We have very high regard and respect for Honorable Supreme Court of India. We have already broadband internet services going on and the Wi-Fi internet services are going on in Jammu and Kashmir. There is no ban on broadband internet and Wi-Fi internet. Yes, there is still ban on mobile internet, but it is because of the national security. 2 months back, the mobile internet services was resumed, but we have seen there was so many rumor mongering in Jammu and Kashmir. It was Pakistani terrorists, separatists and other anti-national forces. Those are trying to use this mobile internet against the country, and it is our priority to make all measures for the safeguard of people of Jammu, Kashmir and Ladakh, and that was why internet facilities was earlier banned.